needed an insurance policy to stop Trump from winning in 2016, those same forces feel like they need another insurance policy now. It's beyond obvious. They're worried that Trump's not just going to run again, but that he's going to win again. And rather than take him on in a court of ideas, they want to take him off the court altogether.
As Laura told you, the Democrats' new mantra is, if you can't beat him, indict him. And they think that by going after Trump legally, they will stop any chance of him running for president again. But not so fast. My next guest served in both the Reagan and Bush 41 administrations, and he says that even if Trump were to be convicted under a law governing the misuse of federal government documents, he could still serve as president. Joining me now is constitutional lawyer David Rivkin. And David, you say the Dems' theory is deficient on both the statutory and constitutional grounds. How so?
The Supreme Court has made it very clear in two cases dealing with an effort to add additional qualifications for congressional offices. And, of course, you have qualifications for office of a presidency, that no new qualifications can be added. It's fundamentally incompatible with our constitutional structure. And this is nothing more than an effort to add another qualification to being able to run and serve as president, namely not being convicted under this particular statute, and that's 2701, which is the statute that Peter Navarro was talking about. That is not even a close call. It would not fly at all. Now, it's possible. I've seen some people suggest that you just put a legal cloud over Trump's head on this issue, which is kind of an example of lawfare. But I don't think that is at all plausible. So that language in the statute, the inability to hold an office under the United States, does not apply to either members of Congress or the president.
But, David, play this out for me. So if we're actually going to get rid of that specific language in the statute, that's going to actually go to the Supreme Court. The Supreme Court will have to make that decision vacating that part of the statute, or how does that play out?
I think that if an effort was made to actually enforce that particular punishment, it would be litigated. It's a pure question of law. It would be litigated pretty quickly. I think that it assumes, by the way, that President Trump would be actually convicted. You can proceed under, Declaratory Judgment Act to obtain a declaration that would not apply to you. I would venture a guess that it would be, the right position would prevail at the District Court, Court of Appeals, and in the Supreme Court. As I said, I'm not concerned about it. By the way, my other overarching point is that I'm not at all convinced that there is any prospect that the president would be indicted under those three statutes. And by the way, the previous guest talked quite a bit about arguments can be made that those statutes he has not violated them. I think the more fundamental issue can be whether or not those three statutes even apply to him, because of the overarching force of Presidential Records Act, which is a very narrow, very precise statute, applies to only former presidents, and is, in my opinion, fundamentally incompatible with the applicability of those three criminal statutes that deal with various aspects of mishandling criminal documents. To explain very briefly, while you're supposed to return records for presidential records to the archivist, it sets the process of negotiating with the archivist and litigating any issue in the District Court for the District of Columbia. That statute is fundamentally, the entire statutory scheme is incompatible with the notion that he could be prosecuted for holding those records. So I think that's an important issue that goes not just to disqualification, but any ability to prosecute him successfully.
Well, David,